All right, welcome everybody. I am going to take a look at the Supreme Court's decision today on domestic abusers not being allowed to carry guns. So I saw a headline on this. I am a practicing attorney. I've been practicing for about 7 years. And I was a law clerk before that, and obviously I went to law school. So I feel like I can offer some insights on this, and I'm intellectually curious myself to see, what the Supreme Court had to say. So, this is my react video to United States versus Rahimi, which looks like it was a petition for writ of certiorari from the Fifth Circuit Court of Appeals. It's my understanding that the Fifth Circuit ruled unanimously for Rahimi. So let's see what we've got here. This is a slip opinion. I believe it just came out today. Yeah, decided June 21st, 2024. It's 103 pages, but that's not, some of it's just the syllabus at the beginning. The syllabus is kind of an overview of everything that was decided and the reasoning and all that. So I just want to do a quick overview of everything. Chief Justice Roberts delivered the opinions. My understanding it was an 8-1 decision. So let's see. Let's go all the way down. Okay, dissenting opinion, Justice Thomas, no surprise there. So this is a lengthy opinion. So the holding: when an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed, consistent with the Second Amendment. Pages 5 to 7. Since the founding, the nation's firearm laws have included regulations to stop individuals who threaten physical harm to others from misusing firearms. As applied to the facts here, Section 922G8 fits within this tradition. That is probably a federal, looks like it's a federal, it's either a federal statute or a CFR, Code of Federal Regulations, I'm guessing. I will, be able to identify it when I get down into the opinion. So, continuing on. The right to keep and bear arms is among the fundamental rights necessary to our system of ordered liberty. Right is not unlimited. All right, so let's get down into the actual guts of. Looks like there was a. All right, I want to give it sort of a 30,000-foot overview of what was decided here, and this is just my initial react video. So I haven't read this before. I know it was an 8-1 decision with everybody except for Justice Thomas deciding to side with the United States and limit this individual's ability to keep firearms. But that key word so far is limited. So it is not unlimited. I'm curious to see if they elaborate on that word or if they're going to leave it to the lower courts to interpret what that word means. So let's see. So challenged regulation. So this was a challenge to probably a CFR. Holding Section 922G8 survives Rahimi's challenge. Rahimi's facial challenge to Section 922G8 requires him to establish that no set of circumstances exists under which the act would be valid, and that's citing to an older Supreme Court case. Here, 922G8 is constitutional as applied to the facts of Rahimi's own case. Rahimi has been found by a court to pose a credible threat to the physical safety of others. See 922GC1. And bear with me here. I need to just change something. Sometimes the Supreme Court will kick it back down to a lower court and say, continue from here. sometimes the circumstances are such that the Supreme Court it just rules with finality, and it doesn't need to kick it back down to the lower court. But usually it's them clarifying a point and kicking it back down to a lower court. So the decision here, sections, I imagine it's CFR. I don't know what chapter of the regulations it is. I know it's a federal regulation. Section 922G8 survives Rahimi's challenge. The court reviewed the history of American gun laws extensively in Heller and Bruin. At common law, people were barred from misusing weapons to harm or menace others. Such conduct was often addressed through ordinary criminal laws and civil actions, such as prohibitions on fighting or private suits against individuals who threatened others. By the 1700s and early 1800s, though, two distinct legal regimes had developed that specifically addressed firearms violence: the surety laws and going armed laws. Surety laws were a form of preventive justice, which authorized magistrates to require individuals suspected of future misbehavior to post a bond. If an individual failed to post a bond, he would be jailed. If the individual did post a bond and then broke the peace, the bond would be forfeit. Surety laws could be invoked to prevent all forms of violence, including spousal abuse, and also targeted the misuse of firearms. These laws often offered the accused significant procedural protections. The going armed laws, a particular subset of the ancient common law prohibition on affrays or fighting in public, provided a mechanism for punishing those who had menaced others with firearms. Interesting. Under these laws, individuals were prohibited from riding or going armed with dangerous or unusual weapons to terrify the good people of the land. Those who did so faced forfeiture of their arms and imprisonment. Prohibitions on going armed were incorporated into American jurisprudence through the common law, and some states expressly codified them. Interesting. Always interesting to see the Supreme Court, the highest court of the land, appeal to common sense. So together, the common sense does not always apply in the legal realm. So it is interesting when you see the Supreme Court itself appeal to common sense. Together, the surety and going armed laws confirm what common sense suggests. When an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. Section 922G8 is not identical to these founding-era regimes, but it does not need to be. Like the surety and going armed laws, Section 922G8C1 applies to individuals found by a court to threaten the physical safety of another. This prohibition is relevantly similar to those founding-era regimes in both why and how it burdens the Second Amendment right. Section 922G8 restricts gun use to check demonstrated threats of physical violence, just as the surety and going armed laws do, unlike the regulation struck down in Bruin. Section 922G8 does not broadly restrict arms use by the public generally. Interesting. The burden that Section 922G8 imposes on the right to bear arms also fits within the nation's regulatory tradition. While the court does not suggest that the Second Amendment prohibits the enactment of laws banning the possession of guns by categories of persons thought by a legislature to present a special danger of misuse, see Heller, Section 922G8 applies only once a court has found that the defendant represents a credible threat to the physical safety of another. Section 922G8C1, which notably matches the similar judicial determinations required in the surety and going armed laws. Moreover, like surety bonds of limited duration, Section 922G8 only prohibits firearm possession so long as the defendant, quote, is subject to a restraining order. That reminds me of when Bill Clinton said that depends on what the meaning of the word is, but it does matter. Clinton was a lawyer. Obviously, the Supreme Court justices are all lawyers. So that quote around the word is shows that words matter in the legal field. So Finally, the penalty, another relevant aspect of the burden on the Second Amendment right to bear arms, also fits within the regulatory tradition. The going armed laws provide for imprisonment, and if imprisonment was permissible to respond to the use of guns to threaten the physical safety of others, then the lesser restriction of temporary disarmament that Section 922G8 imposes is also permissible. The court's decisions in Heller and Bruin do not help Rahimi. While Section 922G8 bars individuals subject to restraining orders from possessing guns in the home, Heller never established a categorical rule that the Constitution prohibits regulations that forbid firearm possession in the home. Indeed, Heller stated that many such prohibitions, like those on the possession of firearms by felons and the mentally ill, are presumptively lawful. And the court's conclusion in Bruin that regulations like the surety laws are not a proper historical analog for a broad gun licensing regime does not mean they cannot be an appropriate analog to a narrow one. So interesting. The court is distinguishing its decision here from Heller and Bruin, which are earlier decisions, by saying, look, here the regulation pertains to a specific individual, and so because that is so, the surety laws and what was the other category? I'm doing this on the fly. This is just a React video, so let's see. It was surety laws and going armed laws. I've never heard of that phrase, so it's hasn't taken root in my brain yet. Surety laws and going armed laws. So these earlier decisions, Heller and Bruin, rejected the historical analogs of the surety laws and the going armed laws, surety bonds and going armed laws, by saying, look, here in this instance, this is different because we're dealing with a specific individual, and so it's appropriate to look at the historical analog of the surety laws, where I guess an individual was required to post a bond if they were going to use weapons, and the going armed laws, which, what were those again? Going armed laws provided for imprisonment, and if imprisonment was permissible to respond to the use of guns to threaten. No, that doesn't define going armed laws. All right, here. The going armed laws, a particular subset of the ancient common law prohibition on affrays or fighting in public, provided a mechanism for punishing those who had menaced others with firearms. So it sounds like you had to have a history already. And I think this Rahimi guy, well, I know he was, I don't know if he was convicted of domestic violence. I don't want to speculate. I don't know too much about it. I just saw in the news this came out today and wanted to do my reaction. So here's where we get to the actual opinion. This is a slip opinion, and as you can see, what that means is, among other things, this opinion is subject to formal revision before publication in the United States reports. Readers are requested to notify the reporter of decisions of any typographical or other formal errors. So maybe we find a typo and get to correct the Supreme Court of the United States. I doubt it, but hey, anything's possible. So Chief Justice Roberts delivered the opinion of the court, and what is interesting up here is Roberts delivered the opinion of the court. So that's one in which Alito, Sotomayor, Kagan, Gorsuch. I've only ever seen his name written, so I don't know how it's pronounced. Kavanaugh, 6, Barrett, and Jackson joined. So eight justices, all of the conservative justices except for Thomas. Got Gorsuch? Maybe it's Gorsuch. It's terrible that I don't know how to pronounce his name, but as a practicing lawyer, I haven't had much occasion to really get into Supreme Court opinions. So Gorsuch, Kavanaugh, Barrett, and Jackson filed concurring opinions. Interesting. So Justice Jackson did her own concurring opinion. I don't know that she's done many so far, quite frankly. And then Thomas filed a dissenting opinion. So Justice Roberts wrote this opinion, and the 7 other justices who were not Justice Thomas joined in. So a federal a statute prohibits an individual subject to a domestic violence restraining order from possessing a firearm if that order includes a finding that he represents a credible threat to the physical safety of an intimate partner or a child of the partner or individual. Respondent Zaki Rahimi is subject to such an order. The question is whether this provision may be enforced against him consistent with the Second Amendment. In opinions such as this one, the Supreme Court, the appellate court, whatever court is reviewing a lower court's decision, is going to have a specific issue that they're going to decide in a case. And so the issue in this case is whether so it's not a regulation, it's a statute, 18 U.S.C. section 922 G8. The issue raised on appeal that the Supreme Court is deciding is whether that statute can be enforced against Zaki Rahimi without violating the Second Amendment. So this is literally the Supreme Court deciding whether a law is constitutional. All right. So Rahimi grabbed his girlfriend in a parking lot by the wrist, dragged her back to his car, shoved her in, causing her to strike her head against the dashboard. When he realized that a bystander was watching the altercation, Rahimi paused to retrieve a gun from under the passenger seat. CM took advantage of the opportunity to escape. Rahimi fired as she fled, although it is unclear whether he was aiming at CM or the witness. Rahimi later called CM and warned that he would shoot her if she reported the incident. All right, so this guy is obviously a problem, to say the least. Violent tendencies demonstrated, not theoretical. So CM, the girlfriend, got a restraining order. He violated the order by approaching her home at night, also began contacting her through several social media accounts. So this guy was not letting it go. Threatened a different woman in November with a gun, resulting in a charge for aggravated assault with a deadly weapon. Okay, so this is a man who had a demonstrated history of violent behavior, including the use of guns in furtherance of that violent behavior. So, let's see. Police obtained a warrant, discovered a pistol, a rifle, ammunition, and a copy of the restraining order. So he was not oblivious to the restraining order. So he was then indicted on federal charges, federal gun charges. Was the restraining order a federal one? I don't know. No, a state court. State court issued a restraining order against him. I don't understand the precise mechanics of how that works and how the federal statute comes into play. We'll see what the actual text is. Okay, so it gets into it right here, right under my nose. A prosecution under Section 922G8 may proceed only if 3 criteria are met. First, the defendant must have received actual notice and an opportunity to be heard before the order was entered. And so what that means, that actual notice, that means that Rahimi must have been found to known that there were restraining order proceedings against him and had the ability to go and argue in court that, why, either to not contest the restraining order and say, hey, judge, look, I get it. No objection, basically, no opposition, or to resist the entry of the restraining order. So looks like Rahimi had actual notice and the ability to go argue before the judge as to why or why not the restraining order should be imposed. Second, for a prosecution to proceed under Section 922G8, the order must prohibit the defendant from either harassing, stalking, or threatening his intimate partner or his or her partner's child, or engaging in other conduct that would place the partner in reasonable fear of bodily injury to the partner or child. So it follows that there was such an order here. This guy's behavior was obviously unacceptable and violent towards his ex-girlfriend. Defendant's intimate partners include, obviously include the girlfriend. Third, to proceed with the prosecution under Section 922G8C, the order must either contain a finding that the defendant represents a credible threat to the physical safety of his intimate partner or his or her partner's child, or by its terms explicitly prohibit the use, attempted use, or threatened use of physical force. All right, so Rahimi's restraining order met all three criteria. Rahimi moved to dismiss the federal indictment, arguing that Section 922G8 violated on its face the Second Amendment right to keep and bear arms. Concluding that circuit precedent foreclosed Rahimi's Second Amendment challenge, the district court denied his motion. So the district court is the trial court, and so that's the lowest level court that gets appealed to the circuit court, and then any appeal from the circuit court, which is the intermediate level, goes to the Supreme Court of the United States. So after that, challenge to the statute was denied in district court. He then pleaded guilty. On appeal, he again raised his Second Amendment challenge. The appeal was denied, and Rahimi petitioned for rehearing en banc. So what that means is he appealed to the Fifth Circuit, his appeal was denied, and then he did a motion to have not just a panel of the Fifth Circuit decide his appeal, but the entire body of justices from the Fifth Circuit. And so he wanted the entire Fifth Circuit to decide the issue. While Rahimi's petition for rehearing en banc was pending, the Supreme Court, New York State Rifle and Pistol Association Incorporated v. Bruin in 2022. In Bruin, we explained that when a firearm regulation is challenged under the Second Amendment, the government must show the restriction is consistent with the nation's historical tradition of firearm regulation. And so that it sounds like Rahimi was going, hey, look, Bruin, there's these earlier precedents that say you can't talk about surety laws, surety bond laws, and going armed laws. But the Supreme Court in this case said, no, those were categorical restrictions. In this case, what we're dealing with is a specific individual and restrictions on a specific individual. So, in light of Bruin, the Fifth Circuit panel, withdrew the prior opinion and ordered additional briefing. A new panel then heard oral argument and reversed. Surveying the evidence that the government had identified, the panel concluded that Section 922G8 does not fit within our tradition of firearm regulation. All right, and then after that, the United States, the federal government, I guess the Department of Justice, filed a petition to the Supreme Court for a writ of certiorari, which leads us to this opinion. Let's see. When a restraining order contains a finding that an individual poses a credible threat to the physical safety of an intimate partner, that individual may, consistent with the Second Amendment, be banned from possessing firearms while the order is in effect. Interesting. So, even though this is 8-1, it looks like that's going to be of limited effect. So, a lot of restraining orders expire. Some jurisdictions it becomes a protective order, but even then they're they're not unlimited. They are not infinite. So this is a very specific holding. When a restraining order contains a finding that an individual poses a credible threat to the physical safety of an individual partner, that individual may, consistent with the Second Amendment, be banned from possessing firearms while the order is in effect. So since the founding of our nation's firearm laws have included provisions preventing individuals who threaten physical harm to others from, since the founding, our nation's firearm laws have included provisions preventing individuals who threaten physical harm to others from misusing firearms. So this ruling has broad implications beyond just domestic violence, right? It sounds like the court is opening the door to things like red flag laws, right? And so we'll see what the states do in terms of either enforcing existing red flag laws or enacting new red flag laws. This opinion is a roadmap to red flag laws, where if the red flag laws are pertaining to a specific individual and are consistent with the tradition of surety bonds by firearms users and going armed laws, it looks like those are constitutional within the Second Amendment. So, obviously with the history that of shootings in this country we've seen since Columbine. There's been a lot of debate over the Second Amendment, and this decision clarifies a lot of that, in my opinion. I think we will see red flag laws either enacted or enforced, and any challenges to those, it depends. Law is a very specific thing. It depends on how those laws are written, but those that are written the right way and not categorical denials of the right to bear arms, as long as they pertain to a specific individual in terms of their enforcement, it looks like they're going to be upheld going forward. So, interesting. Okay, I don't need to get into the history lesson they're providing here. Like most rights, though, the right secured by the Second Amendment is not unlimited. So, the Supreme Court is kind of it's distinguishing some of these earlier laws, Heller and Bruin. Heller, I think, was I'm rusty on my Second Amendment law. I think Heller was the one where Scalia, that's DCV Heller, Scalia authored that opinion and said you have an individual right to bear arms. I'm pretty sure that's what Heller was. So, look, the Supreme Court is clarifying here that it's not unlimited, and if you get crazy and, you have a restraining order against you by, an intimate partner, that was brought about by an intimate partner petitioning a court, you can have your guns taken away. And you're not going to run afoul of the Second Amendment. So, bearing these principles in mind, we conclude that Section 922G8 survives Rahimi's challenge. This was a facial challenge. It was a challenge to the language of the statute itself. So, Rahimi was asking that the Supreme Court declare a federal law enacted by Congress to be unconstitutional. And that's a tough sell, right? Because Congress has been declared many times by the Supreme Court to have plenary power. And plenary power is broad power. Congress really has a lot of power to pass the laws it wants to. It is, of course, subject to the Constitution, but there's quite a bit of deference that, even the Supreme Court, a co-equal branch of the government, is going to give to Congress. And that it goes also to the principle of constitutional avoidance. And this is a principle that the Supreme Court follows regularly. It's this issue of constitutional avoidance. If a case can be decided in a way that does not, such that the court does not have to get to whether behavior or a statute or a regulation was constitutional, they will take the lesser route, the least burdensome route, and they will not just declare a statute or a regulation to be unconstitutional simply because they can. However, here, this was an actual challenge to the constitutionality of the language of the law itself, and so there's no, I don't see any way for constitutional avoidance here. And as the court notes, however, because again, it's a congressional law. Congress has a lot of power, and even being a co-equal branch, the Supreme Court's going to give Congress deference, and you know, if it can avoid declaring a law unconstitutional, it will. And so this is the most difficult challenge to mount successfully, because it requires a defendant to establish that no set of circumstances exist under which the act would be valid. So that's a heavy burden. You have to, you know, it takes a lot to get a law declared unconstitutional. Here, the provision is constitutional as applied to the facts of Rahimi's own case. All right. So just reiterating, the court's reiterating its rationale here. This court reviewed the history of American gun laws extensively in Heller and Bruin. From the earliest days of common law, firearm regulations have included provisions barring people from misusing weapons to harm or menace others. The act of going armed to terrify the king's subject was recognized at common law as a great offense. And that's an English legal decision from 1686. Parliament began codifying prohibitions against such conduct as early as the 1200s and 1300s, most notably in the Statute of Northampton of 1328. In the aftermath of the Reformation and the English Civil War, Parliament passed further restrictions. The Militia Act of 1662, for example, authorized the king's agents to seize all arms in the custody or possession of any person judged to be dangerous to the peace of the kingdom. Kingdom, interesting. I got an E on the end of that. Okay, so look, the Supreme Court, what they're doing here, they don't really have to do this. It's useful for future courts to understand the rationale. You know, they don't have to do this history lesson. They could. The Supreme Court's fully within its rights to just say, nope, statute is constitutional. It doesn't really have to explain itself. And I think what the court is doing here in explaining itself is setting this up so that it gives lower courts and lawyers guidance in how to apply this opinion going forward. You know, sometimes we see very short decisions from the Supreme Court, but not that I'm a Supreme Court expert. I'm not. I'm just, but I am an attorney, and I do read a lot of case law. And so, what I think the Supreme Court is doing here is helping courts and attorneys understand the rationale, so that going forward, when we see challenges to, I'm sure we're going to see challenges to red flag laws and new efforts to pass red flag laws, and any new statutes are sure to be challenged at some point. And so the history lesson is not just the Supreme Court talking to hear itself talk, right? This is giving guidance to future attorneys and courts when those inevitable challenges arise going forward. Through these centuries, English law had disarmed not only brigands and highwaymen, but also political opponents and disfavored religious groups, right? And so that's the argument on the other side, is that, look, there's this history of, you know, people in power not just going after the bad guys, but political opponents and disfavored religious groups, right? Minority groups. And so, you know, that was the founders' rationale for enacting the Second Amendment. By the time of the founding, however, state constitutions and the Second Amendment had largely eliminated governmental authority to disarm political opponents on this side of the Atlantic. Across the pond, over here in the United States. But regulations targeting individuals who physically threatened others persisted. Interesting. Such conduct was often addressed through ordinary criminal laws and civil actions, such as prohibitions on fighting or private suits against individuals who threatened others. So that's what we saw in the syllabus. It's kind of reiterated. It's getting more detailed here. I won't get into all these details. This is an interesting read, just in terms of the history lesson. Beyond the scope of what I'm going to do in this stream, but it is quite interesting, the history. Communities sometimes resorted to public shaming or vigilante justice to chastise abusers. Sureties provided the public with a more measured solution. It reminds me of the scene in Game of Thrones when Cersei gets walked through the streets. Shame rings the bell. I wonder, I don't know that it actually worked. It didn't shame Cersei. I mean, it did in the moment, right? But she eventually went hellfire brimstone, didn't she? Wildfire, more accurately. Let's see. Yeah, so again, the history lesson that the Supreme Court is giving us, it is very interesting. I find it interesting. And the reason they're doing that is to provide a rationale so that going forward, there's not mass confusion among the courts and lawyers about how to apply this opinion. And it will be applied going forward. I'm certain of that. Taken together, surety and going armed laws confirm what common sense suggests. When an individual poses a clear threat of physical violence to another, the threatening individual may be disarmed. Okay. And so I want to actually go back to this comment. Section 922G8 is by no means identical to these founding era regimes, but it does not need to be. And so I think what the Supreme Court is saying here is, look, and this is what the Supreme Court does a lot, is they will they'll draw from earlier laws to address new laws, right? They'll draw from the rationale, the writings of the founders, people who wrote the Constitution, if it's unclear what the intent was. And so that is how the Supreme Court is able to connect or make rulings on brand new laws that did not exist when the Constitution was written. They can, by analogy, refer to use their phrase, founding era regimes. And so that's what they've done here, is they've gone back and looked at, laws as old as the 1200s in England. And so the English common law is, you wouldn't think it, most people probably don't realize that English common law, to the extent that statutes are not enacted that abrogate the common law, but English common law is a very powerful thing in the United States. Tort law, negligence claims, personal injury lawsuits arise out of the British common law. And here we see, just today, the Supreme Court of the United States deciding whether a federal statute passed by the United States Congress, whether or not it is constitutional, cites to this common law tradition going back to the 1200s of society, the government saying this individual is dangerous and cannot be trusted with a weapon. So common law is a very powerful thing. English common law carries a lot of weight in the United States. So let's see. All right, so that's that. In short, we have no trouble concluding that Section 922G8 survives Rahimi's facial challenge. The dissent reaches a contrary conclusion, primarily on the ground that the historical analogs for Section 922G8 are not sufficiently similar to place that provision in our historical tradition. Um, the dissent, however, does acknowledge that Section 922G8 is within that tradition when it comes to the why of the appropriate inquiry. The objection is to the how. I'm not going to get into Justice Thomas's dissent here. If anybody makes it this far in the video and wants a review of Justice Thomas's dissent, I will happily make another video, but that is beyond what I'm going to review today. Interesting. So, finally, in holding that Section 922G8 is constitutional as applied to Rahimi, we reject the government's contention that Rahimi may be disarmed simply because he is not responsible. Responsible is a vague term. It is unclear what such a rule would entail, nor does such a line derive from our case law. All right, so being merely irresponsible is not enough to disarm somebody. Yeah, so that's what they did. It's what I said earlier in this this stream/video. Court clarified the law. An individual found by a court to pose a credible threat to the physical safety of another may be temporarily disarmed, consistent with the Second Amendment. And so this paves the way for basically, and I'm not a criminal attorney, but what this means is that Rahimi's conviction cannot be set aside by him saying, I was convicted under a federal statute that was unconstitutional, and so because the federal statute was unconstitutional, my conviction goes away. That argument appears to be done. His challenge to the statute under which he was convicted has failed, and so now it's getting kicked back down to the Fifth Circuit for further proceedings consistent with this opinion. I don't entirely know what the Fifth Circuit, I thought the appeal to the Fifth Circuit was the facial challenge to the Constitution. There may be ancillary issues that he was appealing, ineffective assistance of counsel, things like that. So it may be that this gets kicked down to the Fifth Circuit to say, okay, well, the statute's constitutional, so Rahimi's not going to get out of his conviction by saying the statute was unconstitutional. If there's other ancillary constitutional issues raised on appeal, ineffective assistance of counsel, or errors that the district court made in the trial proceedings. This one didn't go to trial, right? He pleaded out. But errors from the district court that can raise issues on appeal that the Fifth Circuit can look at. Maybe this is getting kicked back down for the Fifth Circuit to decide those things. I simply don't know. But interesting opinion, powerful opinion, and one that is going to be cited many, 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 many times going forward. And so, look, we may see red laws being enforced, red flag laws being enforced. We'll probably see maybe even amendments to existing red flag laws. I'm not an expert on red flag laws, certainly, but I read a lot. So I know that there have been efforts to enact them, and so we may see either new red flag laws being enacted or existing red flag laws being changed so that it's brought within the constitutional scope of the Rahimi decision that came out today, in an effort to avoid future challenges on constitutional grounds like Rahimi made in this case. So very interesting, a very weighty decision that is going to have a lot of implications for courts, attorneys, criminal defendants who are subject to domestic violence laws. I imagine, well, let's see. So this wasn't just the court upholding the constitutionality of Section 922G8. This was a broad holding that can apply to other statutes too, I think. So let's see. Yes. An individual found by a court to pose a credible threat to the physical safety of another may be temporarily disarmed consistent with the Second Amendment. Okay. Yeah, so again, this applies to red flag laws. This is not just limited to Section 922G8 and domestic violence prosecutions and convictions. This is broader than just domestic violence scenarios. So this applies to, any person found by a court to pose a credible threat to the physical safety of another. So that's interesting too. This is not paving the way for laws to proactively disarm an individual without court intervention. So, and I think that's important because, procedural rights matter, procedure matters. And so what this means is that, nobody's going to be disarmed without due process and a chance to have their day in court. And it's going to require a showing to the court of a credible threat to the physical safety of another. And even then, maybe temporarily disarmed, consistent with the Second Amendment. So, temporarily, I didn't see in here where it elaborated this opinion on what that word means, temporarily. And so, that seems to be grounds for perhaps future case law, what that word temporary means. So, anyway, that's my thoughts on the United States versus Rahimi opinion that came out today. If anybody would like to see further analysis on this, if you want me to go over Justice Jackson's concurring opinion or Justice Thomas's dissent or any other justice's concurring opinion, there were several, Sotomayor's. I'm interested in Justice Jackson because she's the newest justice on the court, right? And so, but also Justice Thomas dissented. If you'd like me to cover any of that in another stream or video, please let me know. I'm happy to do that. If you would like to see more of this content, let me know in the comments. Give me a like, give me a subscribe. I would really appreciate it. And that's all I've got for today. Thank you for joining me. Thanks for watching.